Well, thank you very much for joining me in this video. I was out for a drive the other day and I went by a property we had listed some time ago, and it jogged my memory. It made me think about caution on title, and that was something I wanted to talk to you about. So the story behind this particular property, it was an older property and it had been an older family that was living in it, and it was dated, but it was on a lovely piece of ground in a nice residential area, and it had lots of frontage, and it was ideal to be severed and to create another decent lot. So it was up for sale. The people had passed away and it was being sold by the executor, but it was elderly people involved. An offer came in, and that offer was ultimately negotiated and accepted. And then the buyer, who I might add was a realtor, the buyer started to complain, had his lawyer search title, and he wasn't happy with the description on title. It was, as I said, it was in the family for some time, so it was an older period of time when that property was last registered on land titles and originally the registry system. So he insisted that the seller, at his expense, do a new survey. Normally it would be the buyer's expense. He's saying it's not a registrable title, so the seller agreed, paid for a new survey. He looked at that, he wasn't happy with the survey. He said, I wanted a large abatement in the price because I'm not happy with, there's some discrepancies and some questions and blah, blah, blah. And what he did at that point was he registered a caution on title. What that does is that prevents the seller from encumbering or selling the property to anyone else until that caution is lifted. It made me think of a problem we had many years ago here in St. Catharines. One of the large apartment buildings in the north end was being sold, and it was purchased by a company, I think it was, my memory serves me right, something like Great Western Ontario Investment Corp, something very close to that. So they brought in an offer that was accepted, and it was conditional on a review of the rent rolls. So after the offer was accepted, the rent rolls were gathered and provided to the seller, or to the buyer by the seller, and the buyer found a discrepancy on one of the rents. Now it was a 100-unit apartment building, and so there was, put that in perspective, there was one rent that was questionable as to whether or not the last notice of increase was delivered properly or not. So what this company did was they said, we want a huge abatement in the price, hundreds of thousands of dollars abatement in the price, and they registered a caution on title. Now, as I said, what the caution on title does is prevents the seller from selling it to anybody else or from encumbering it. In this particular case, this apartment building, the owner was in very good standings, but his mortgage was coming due, and he couldn't renew the mortgage without having that mortgage drop from first place because of the caution that was registered. So his hands were tied because of the caution on title. And this particular company had a habit of doing that. They would go in, put in an offer, find some minuscule discrepancy, and tie up the property with a caution on title. Now, there's a time when a caution on title is an advantage. Makes sense. You're negotiating to buy a property. The seller's not acting in good faith. He's got somebody else in the wings who's come along and offered him more. For whatever reason, he wants out of your deal. And you know it's not fair, it's not right. And if you register a caution on title, it prevents him from selling it to anybody else until the dispute between you and himself is resolved. It's not without liability. If I am the buyer and I register a caution on title and it proves to be frivolous, then I'm going to be on the hook for damages, punitive damages perhaps, probably legal costs. It can be very, very expensive. So you got to be careful about what you do with a caution on title or notice of pending litigation. The problem though, and this is what I want to zero down on, is if I as the buyer am a shell company, I don't care. If I'm a shell company, I can tie your hands, and that's what was going on with this apartment building in the north end. The company that was putting these offers in, if they got sued and it was successful, they would just walk away because they would buy under this umbrella corporation, and when it was successful, they would transfer it to another name. So they always maintained no assets in the purchasing company. And so you can get a judgment against them for costs, punitive damages, all kinds of things, but it's not enforceable because if you sue the corporation has no assets. And that brings me to this business about an assignment. You may, in good faith, enter into a relationship with a buyer and negotiate and everything is fine. But then the buyer wants to assign it to somebody else and you haven't negotiated it with somebody else. It may not be somebody you're happy with. And there's a clause that's one of the legal clauses that's available for you. And I want to read it to you and I want to tell you how to deal with it if and when you see it. It says, the buyer shall have the right at any time prior to closing to assign the within offer to any person, persons, or corporation, either existing or to be incorporated. And upon delivery to the seller of notice of such assignment, together with the assignee's covenant in favor of the seller to be bound hereby as buyer, the buyer herein before named shall stand released from all further liabilities hereunder. What's it saying? It's saying I want the right to be able to assign this, and if I assign it, the assignee will accept the responsibility of the agreement and I walk away. Well, there can be some problems there. The first thing is you don't know whether the assignee has credible credit. The assignee may be extremely shaky. You've done your homework and you've decided you're willing to sell it to this buyer, but the person he's assigning it to, that's a whole different ballgame. But it also allows him to assign it to a corporation, and that corporation can be just newly formed. If the corporation is newly formed, it has no assets. So as I said before, you can sue the corporation, you can get a judgment against the corporation, but there's nothing to enforce it. So how do you deal with this? Well, the first option is just cross it out. Just say it's not acceptable, cross out the clause. The second option is modify the clause. If you're going to modify the clause, this last little part where it says the buyer herein before named shall stand released from all further liability herein, cross that out and say that the signator, John Doe, shall remain personally liable for the fulfillment of the contract. Add that in. So you're saying, I covenanted with you to sell it and you guaranteed me you were going to close. So you just keep that guarantee in place. That's the second thing you can do. The third thing that you can do is make sure that it's a large deposit, or if it's not a large deposit, on accepting this assignment clause, say upon notification of the assignment, the buyer shall increase the deposit by such and such an amount. Because there, if you've got a large enough deposit, you can claim against damages on that deposit. So be very, very careful. Remember, when you're representing a seller, you got to represent his best interest. And if you're going to end up with the buyer being a shell corporation and there's a danger of caution on title, not bargaining in good faith, anything like that, you are not looking after your seller's best interest unless you protect him in one of the ways I mentioned. Thank you very much for joining me in this video. I look forward to talking to you again next week.